The Supreme Court of the United States just unanimously rejected reconsideration in a firearm confiscation case, and almost no one is talking about what that actually means. No press conference, no detailed explanation, no warning to the millions of lawful gun owners who could be affected by this decision going forward. Just a quiet denial that may have massive consequences for constitutional rights. And make no mistake, when all 9 justices agree not to step in, silence itself becomes the message. This wasn't a minor procedural dispute. This wasn't a fringe legal theory. This was a case that directly raised the question of whether police and government officials can confiscate firearms from a private home without a warrant, without criminal charges, and without judicial approval, simply by invoking public safety concerns. The Supreme Court had already ruled on this exact issue just a few years ago, unanimously, clearly. Yet lower courts found a way around it, and now the Supreme Court has declined to correct them. So today, we're breaking down exactly what happened, why this case matters, and how a single denial may have quietly reshaped the balance between gun rights, property rights, and government power in America. This case began the way many modern firearm confiscation cases do, not with a crime, but with a phone call. A 57-year-old man with no criminal record, no history of violence, no mental health diagnosis, and a valid state-issued pistol license suddenly found himself at the center of a government intervention. The call came from a teenage family member. Law enforcement responded. When officers arrived, they quickly determined that no crime had been committed. No threats, no violence, no charges. Even the officers acknowledged that the man had broken no laws. But what happened next set off a chain of events that would ultimately reach the nation's highest court. Despite finding no criminal conduct, police transported the man to a psychiatric facility for evaluation. Within roughly 12 hours, medical professionals cleared him completely. Doctors found no evidence that he posed a danger to himself or anyone else. The paperwork authorized his immediate release. That should have been the end of it. It wasn't. Before he could leave, a social worker discovered that the man owned firearms. At that moment, the rules changed. The social worker informed him that he would not be released unless he surrendered the combination to his gun safe so law enforcement could confiscate his firearms. No judge issued an order, no warrant was obtained, no court hearing was held, just a condition: give up your guns or remain detained. Faced with the prospect of continued confinement despite medical clearance, the man eventually complied. His firearms were seized, he was released, and a legal battle began that would last years. At the heart of this case were 2 fundamental constitutional protections. First, the Fourth Amendment, which protects against unreasonable searches and seizures and places the home at the highest level of protection. Second, the Second Amendment, which protects the individual right to keep and bear arms. The man argued that both had been violated. His attorneys contended that police entered the legal equivalent of his private domain, seized lawfully owned property, and did so without judicial oversight or probable cause. This argument should have been straightforward because the Supreme Court had already ruled on a nearly identical situation. In 2021, the Supreme Court decided Coniglia v. Strom, a case involving police who entered a man's home and seized firearms following a domestic dispute, citing a vague community caretaking exception under what was known as the community caretaking exception. The court rejected that justification unanimously. Justice Thomas Alito, writing for the court, made it clear: the community caretaking exception does not override the Fourth Amendment's protections of the home. Public safety concerns alone do not allow warrantless entry and seizure inside a residence. Legal scholars across the spectrum hailed the decision as decisive. The message seemed unmistakable. Police cannot sidestep constitutional safeguards simply by labeling their actions as preventative or caretaking. Lower courts were expected to follow that ruling. But in this firearm confiscation case, something unexpected happened. When the case reached the Second Circuit Court of Appeals, the advocates pointed directly to Coniglia. They argued that the facts were functionally identical: warrantless seizure, no criminal conduct, public safety justification, private home. The Second Circuit acknowledged Coniglia, but only barely. In its opinion, the court mentioned the Supreme Court's unanimous ruling exactly once, in a footnote. The court claimed that Coniglia addressed the community caretaking exception, while this case involved a different concept known as special needs exception. According to the appellate judges, that distinction was enough to render the Supreme Court's ruling non-controlling. Same outcome, same constitutional harm, different label. That single semantic distinction allowed the Second Circuit to uphold the seizure. And with that ruling in place, the case headed back to the Supreme Court, not for a full appeal, but for reconsideration. This is where many observers expected the Supreme Court to intervene. After all, when lower courts appear to sidestep unanimous Supreme Court precedent through wordplay, that typically raises red flags. The integrity of the judicial hierarchy depends on lower courts faithfully applying high court rulings, not rebranding exceptions to reach the same result. Yet, without any explanation, the Supreme Court denied reconsideration. All 9 justices, no dissents, no statements, no clarification, just a single line that allowed the lower court's reasoning to stand. Supreme Court denials happen every day, but context matters. This denial effectively allows courts to bypass Fourth Amendment protections by reclassifying warrantless searches under alternate doctrines. It signals that even unanimous Supreme Court rulings can be narrowed into irrelevance if lower courts are sufficiently creative. And most importantly, it sends a message to law enforcement agencies nationwide. There may be a viable path to firearm confiscation without traditional warrants, as long as it's framed correctly. This case didn't just affect one man. It created a blueprint, and that blueprint is already being used. One of the most disturbing aspects of this case isn't just the seizure of firearms, it's how that seizure was justified after the fact. The government didn't argue that police had a valid warrant, they didn't argue that a judge approved the seizure, and they didn't argue that there was an immediate, life-threatening emergency. Instead, they relied on a single concept: consent. According to the government, the man voluntarily provided the combination to his gun safe. Therefore, the seizure was lawful. But that claim collapses under even minimal scrutiny. Consent under constitutional law must be freely and voluntarily given. It cannot be coerced. It cannot be extracted through threats, and it cannot be the product of unlawful detention. Here, the man had already been medically cleared for release. Doctors said he posed no danger. The paperwork authorized him to go home. Yet a non-medical social worker told him he would not be released unless he surrendered access to his firearms. That is not consent. That is leverage. The choice presented was simple and coercive: surrender your property or remain confined indefinitely. No lawyer present, no judge involved, no written order to challenge. In almost any other context, such a scenario would immediately raise red flags. Confessions obtained under threat are thrown out in criminal cases. Contracts signed under duress are unenforceable in civil law. Yet here, the courts treated consent obtained under psychiatric confinement as legally valid. That alone should have triggered Supreme Court review. It didn't. When the case reached the Supreme Court, the government's opposition brief took a revealing approach. Rather than defending the firearm seizure on constitutional grounds, the government focused on procedural posture. They argued that the petitioner failed to raise certain claims in precisely the right way at precisely the right time during the litigation process. Miss a deadline, use the wrong legal theory, frame a claim too broadly or too narrowly, raise an argument at the wrong stage. Any of these missteps can end a case, regardless of the underlying facts. In this instance, the government essentially said, ignore whether police unlawfully seized firearms without a warrant, focus instead on whether the plaintiff used the correct legal labels when challenging the seizure. And the courts agreed. This is where the broader implications begin to emerge. The Fourth Amendment doesn't say your rights depend on procedural perfection. It doesn't say protections vanish if a citizen fails to anticipate every possible legal distinction courts might later invent. Yet modern litigation has turned constitutional enforcement into a technical exercise that favors the government. The facts here were never seriously disputed. No warrant, no criminal charges, no judicial authorization. Firearms seized from a private home, property retained for years.
But none of that mattered once the focus shifted to pleading technicalities. This creates a dangerous precedent. It allows constitutional violations to persist as long as courts can find a procedural excuse not to address them directly. And when the Supreme Court declines to intervene, that excuse becomes entrenched. Supreme Court denials of reconsideration don't come with explanations. That's standard. But silence carries weight when it follows open defiance of precedent. Lower courts are supposed to apply Supreme Court rulings faithfully. When they don't, review is the mechanism that maintains judicial order. Without it, the hierarchy collapses into inconsistency. By denying reconsideration here, the Supreme Court allowed the Second Circuit's reasoning to stand as valid law within its jurisdiction. That reasoning boils down to this. If police cannot seize firearms under one exception, they may be able to do so under another, even if the outcome is identical. That distinction matters far beyond this case. Legal scholars have warned for years about what happens when constitutional protections depend on the name of the exception being invoked. Community caretaking, special needs, emergency aid, public safety, administrative necessity. These doctrines overlap heavily. They rely on similar justifications, and they all serve the same function, allowing government action without warrants. If courts permit these labels to operate independently, constitutional protections become meaningless. Rights no longer depend on substance but on terminology. That's exactly what happened here. The Second Circuit didn't meaningfully distinguish the harms involved. It distinguished the vocabulary, and the Supreme Court let it stand. This case isn't limited to one circuit or one set of facts. Law enforcement agencies pay close attention to appellate decisions. So do municipal attorneys, state legislatures, and federal agencies. When a legal theory survives Supreme Court scrutiny, even by silence, it gains legitimacy. Since this decision, firearm rights organizations have documented an increase in warrantless seizures justified under special needs and public safety rationales. Training materials now reference this case. Policy manuals cite it. Officers are being told there's a lawful path to seizure without traditional warrants, and it's happening quietly. Perhaps the most troubling consequence is how this shifts the burden of proof. Historically, the government had to prove you were dangerous before taking your property. It had to show probable cause. It had to convince a judge. Under the framework endorsed by this denial, the sequence reverses. Property is seized first. Justification comes later. Citizens must fight for years to get their rights restored. That is not how constitutional rights are supposed to work. By denying reconsideration, the Supreme Court didn't say the Second Circuit was right, but it also didn't say the Second Circuit was wrong. And in constitutional law, that distinction matters less than you might think, because silence in this context functions as permission. What makes the Supreme Court's unanimous rejection of reconsideration so consequential is not just what happened to one individual, it's how quickly that outcome has begun to spread. In the months following the denial, firearm advocacy groups, civil liberties attorneys, and legal scholars began tracking how the Second Circuit's reasoning was being used elsewhere. The pattern was unmistakable. Law enforcement agencies started citing the decision as authority for warrantless firearm seizures under special needs and public safety rationales. Training materials began distinguishing coniglia not by its substance but by its label. Officers were instructed that community caretaking restrictions could be avoided if the seizure was framed as a public health or safety intervention. What began as a narrow appellate decision in one circuit quickly transformed into a practical roadmap for avoiding Supreme Court precedent. Before the Supreme Court's 2021 Coniglia decision, reported cases involving warrantless firearm seizures averaged dozens per year nationwide. After Coniglia, that number dropped noticeably as agencies adjusted to the ruling and exercised greater caution. But that trend didn't last. Following the Second Circuit's decision and the Supreme Court's refusal to reconsider it, the numbers began to climb again. Reported seizures justified under special needs, emergency aid, or public safety rationales increased year over year. Agencies had found their workaround. What's particularly concerning is that many of these seizures do not involve criminal charges. In many cases, firearms are taken based on reports, assessments, or administrative determinations that never undergo adversarial review in court. Once seized, the burden shifts to the owner to fight for return, a process that can take years and cost tens of thousands of dollars in legal fees.
Courts aren't the only institutions responding to this new legal landscape. State legislatures have taken notice. In the past 2 years, multiple states have proposed or enacted laws explicitly authorizing emergency firearm removals under special needs or public health frameworks. These laws often bypass traditional warrant requirements, replacing them with expedited administrative processes or post-seizure review. Supporters argue these measures enhance public safety. Critics argue they erode due process and normalize confiscation without prior judicial oversight. Regardless of where one stands on the policy debate, the constitutional concern remains the same. Safeguards that once applied before property was taken are increasingly applied after the fact, if at all, and the Supreme Court's silence has emboldened that shift. Federal agencies have also adapted. Guidance documents and interagency protocols increasingly emphasize collaboration during mental health-related calls involving firearm owners. These frameworks prioritize risk mitigation over constitutional thresholds, often relying on local interpretations of special needs authority. What's notable is not just the substance of these policies, but their confidence. The legal uncertainty that followed Coniglia has been replaced by renewed assurance that seizures can survive judicial scrutiny, so long as they are framed correctly. That assurance exists because the Supreme Court declined to say otherwise. One of the most damaging consequences of this denial is the fragmentation of constitutional protections. Gun owners now experience different Fourth Amendment realities depending on geography. In some circuits, Coniglia still provides robust protection against warrantless seizures. In others, special needs exceptions weaken those safeguards significantly. Two citizens with identical facts could face completely different outcomes simply because they live on opposite sides of a circuit boundary. That is not how constitutional rights are supposed to function. The Constitution does not change at state lines, but judicial interpretation increasingly does. Perhaps the most unsettling aspect of this entire case is how ordinary it began. No criminal act, no violent threat, no judicial finding of danger, just a phone call. That's all it took to trigger a process that ended with a lawful gun owner disarmed for years without due process. Under the framework now endorsed by silence, similar scenarios could happen to anyone. A misunderstanding, a disgruntled acquaintance, a family dispute, a mistaken report. Once the machinery starts moving, safeguards are minimal. Evaluations happen quickly. Decisions are made administratively. Property is seized first, questions are asked later. And even if you are cleared, even if professionals determine you pose no risk, that does not guarantee your rights are restored. This case illustrates a quiet but profound shift in constitutional enforcement. Historically, the government bore the burden of proof before depriving someone of property. It had to justify its actions in advance. It had to persuade a neutral judge. Now, in many jurisdictions, the burden has flipped. Your firearms can be taken first. You must prove you deserve them back. You must navigate complex legal systems to undo an action that never should have occurred without judicial approval. That is a fundamental change, not just for gun owners, but for anyone concerned with due process and limits on government power. The Supreme Court's unanimous rejection of reconsideration does not endorse firearm confiscation. It does not rewrite the Constitution, and it does not overturn Coniglia. But it does something equally powerful. It allows lower courts to reinterpret unanimous precedent. It allows semantic distinctions to override substance. And it allows government actors to test the limits of constitutional protections with increasing confidence. Silence in this context is not neutrality. It is permission to proceed. This case will not be the last of its kind. The framework now exists, the roadmap has been drawn, and without clear intervention, it will continue to be used. Whether one views this issue through the lens of gun rights, property rights, or civil liberties more broadly, the implications are impossible to ignore. When constitutional protections depend on labels instead of principles, no right is truly secure. And when unanimous Supreme Court precedent can be sidelined without consequence, the system itself begins to fracture. This wasn't just a denial, it was a turning point. What safeguards do you believe should exist before the government can confiscate someone's firearms? Should warrants always be required? Should post-seizure review be enough? Or has the balance shifted too far? Share your thoughts in the comments. If you found this breakdown valuable, make sure to like, subscribe, and share it with others who care about constitutional rights and due process. Staying informed is the first line of defense. Stay aware, stay engaged, and stay safe.